I don't think I really probably need to introduce Ray. He's been a cost consultant since 1976, I think was the figure I was given. Most of you may have already dealt with him over the years. If Ray doesn't know about cost consultants, I don't know who does. So I'll leave you with Ray. Thanks very much. As I say, we'll have questions at the end, so I think we'll leave a good 10, 15 minutes for questions, if that's okay. Thank you.
Thanks, Brett, and welcome to everybody here today. I propose to talk about the amendments to Order 63 of the Supreme Court rules, which all of you would know is principally the cost rules. The amendments proposed to take effect from the, or which will take effect from the 1st of April, have significant effects in relation to costs, and in my view, they're the most radical changes to cost rules in my period of time, which is, as Brett said, is almost 40 years. What I propose to do is, I think you've got the bullet point forms that I propose to speak to. They're the areas that I think affect costs mostly and that you should be concerned about. The first of those is Order 63, Rule 17, which relates to amendments to pleadings. And this, in my view, this is a penalty applied to parties that hasn't been considered thoroughly. As you would be aware, previously, if a party amended a pleading, whether with the leave of the court or without the leave of the court, that party was responsible for payment of the other party's costs of an occasion by the amendment. And I've experienced on numerous occasions parties who have issued proceedings, haven't got their claim right, amended 3, 4, 5 times, eventually changed tack totally. And under this new rule, which says that any party amending a pleading, those costs will become costs of the proceeding unless the court otherwise orders. So I emphasise that any party who feels aggrieved by any amendment to any pleading should, at the time of the amendment, ensure that they get an order in favour of their client so that that client is not disadvantaged. If they don't, and often the amendment is by consent and solicitors can be lazy in addressing the orders put before them, they can merely say, costs reserved. Well, that would be a disadvantage, which I'll come to later as well. So you need to, if your party is aggrieved by an amendment, you need to address that at the time. You need to get an order in favour of your client, and you need also, if it's a consent order, to ensure you get that, because at the end of the day, when the trial judge makes a determination, you'll have no interest whatsoever in relation to orders made in relation to an interlocutory application the way through. You'll have no interest in relation to reserve costs because they will become costs of the proceeding as well. It will, unless you address it in that way, I believe parties will be encouraged to just constantly amend their proceeding to get it right. One of the other disadvantages in relation to that is that I believe that in the past, when costs of an amendment to a pleading are taxed, or at least a bill is prepared in relation to the cost, it sometimes identifies to both parties the cost of litigation, and it sometimes leads to a settlement of a matter. That won't happen now. The second amendment that's of concern is the amendments to interlocutory applications. In the past, these costs will now become costs of the proceeding. And again, if your client has been aggrieved by any interlocutory application, unless you seek an order in favour of your client at that time, the trial judge won't be concerned about it at the end. In the past, the registrars have had the power to deal with interlocutory applications where costs have been reserved, but that's been removed from registrars on taxation. The one advantage, I suppose, is that given that interlocutory applications now cannot be taxed until the conclusion of the matter, it'll free up the cost court to deal with much more important matters. So that's one advantage. But it's countered by the disadvantage of not being able to identify to clients how costs can build up easily and perhaps make them see the light as to negotiation. The third point is Order 63 Rule 22 is cost reserved. As I indicated in the past, reserve costs could be dealt with by a taxing registrar whether the court had dealt with them in final orders or not. That opportunity no longer exists. And it meant that on a taxation, you could argue the merits of reserve costs if the judge hadn't included those in his final order. So again, it's important when dealing with reserve costs to get orders if you feel aggrieved by it at the time. Order 63, Rule 24 relates to monies claimed in the wrong court, and most of you are probably familiar that this is something that is constantly exercised in the county court, where somebody might issue proceedings in the county court and recover less than half the jurisdiction of the magistrate's court. This rule was very rarely applied in the Supreme Court, and until the amendment, only applied in relation to proceedings for slander and libel, for which was a requirement to achieve better than $50,000, or you'll be reduced to the lower court scale costs. The amendment to Order 6324 provides a jurisdictional limit in the Supreme Court now, which is $100,000 in other matters apart from libel and slander. The reason that previously hadn't been any jurisdictional limit is because the county court had unlimited jurisdiction. So effectively, the county court now has a jurisdiction of $200,000, because 6324 is a provision to say that you must get more than half the lower court's jurisdiction, otherwise you're limited to the costs of the lower court. By virtue of placing a jurisdiction of $100,000, it's effectively, in my mind, saying that the county court jurisdiction is $200,000. Of interest, the $100,000 is the limit, as you're probably aware, of the magistrates' court. So I think it follows that if the magistrates' court limit is increased, then similarly this amount will be increased, or the county court jurisdiction will be doubled. As you may be aware, in relation to Order 6324, not only is the successful party limited to the lower court's scale costs, the party who's been forced to defend in the Supreme Court when it should have been in the county court has the opportunity of applying for a set-off, so that they would effectively say, we've been subjected to paying costs on a Supreme Court scale when we ought to have been entitled to pay costs on the county court scale. Generally, that would wipe out the cost order. The one provision in the 6324 is that you cannot make a profit. And given the the increase in the Supreme Court scale, which I'll come to later, I think it's probably likely that if you were successful in having 6324 applied, then you would avoid the cost order. The fifth rule that I want to speak to you to is the basis of taxation, and this is one of the most radical changes in the amendments. Effectively, as from close of business today, there will no longer be party costs. The three types of costs that will be ordered as from 1st of April will be standard basis, indemnity costs, or such other basis as a court may direct. Standard basis effectively takes the place of party costs. But it's interesting to note that the description for standard basis costs is exactly the same as the description that previously existed for solicitor-client costs. That is, all costs reasonably incurred and of reasonable amount shall be allowed. Indemnity costs, which were introduced in 2001, are described as all costs shall be allowed except insofar as of an unreasonable amount or have been unreasonably incurred. And on any taxation of costs, if there's any doubt as to whether it was unreasonable, then the taxing offer is directed to favour the person who's the recipient of those costs. Such other basis as a court may direct, in my view, is indemnity, but pursuant to some other basis than the scale. Most people accept or believe that indemnity costs mean a full indemnity. They do not, and Order 63 Rule 28 has to be read in conjunction with Order 63 Rule 34, which provides that costs payable between parties on a standard basis or an indemnity basis shall be in accordance with Appendix A of the scale of costs. So it follows that if you want a full indemnity for your client, you need to get such order from the judge. And to do that, you would need to be armed with an agreement specifying some other basis that you could charge your client other than the scale. Now, I'll talk to you later about the agreement and whether you may not need to have agreements by virtue of the new scale, but it's not sufficient to obtain an order for indemnity costs and say to your client, we've now got everything. You haven't. You'll only get scale costs and of interest, counsel fees, which were never ever covered by scale, are now part of the Supreme Court scale. And I don't think I'd be unique in saying that it's rare to have counsel charged in accordance with scale. So you're going to have a problem in that regard. So if you are able to convince the court to allow your costs in accordance with your fee agreement, you need to be sure in your own mind that your fee agreement is reasonable. Now, I don't think it would be reasonable to say, I want you to allow me $700 an hour as per my fee agreement, when the scale provides $360 an hour plus a loading, which I think will be in the range of 20–25%, so that's equivalent to $450 an hour. Some people do have fee agreements, which I, excuse me, think are fair and reasonable, where because of their experience, their knowledge of it and specialisation in an area, will charge much more. I think $600 an hour is not unusual. The federal court scale provides for $550 an hour plus GST. So $600 an hour I don't think is unreasonable if you can establish that your experience and expertise in an area means that you'll process the action quicker than somebody without that degree of expertise. There's no distinction between what a practitioner should be allowed in the Supreme Court scale. So it doesn't provide for a 3-year solicitor as compared to a 20-year solicitor. It doesn't provide for somebody who's no expertise compared to somebody that has. Whilst the the amendment to the rule provides that the taxing officers have the power to apply a greater allowance than has been ordered by the court, I don't think they would exercise that power unless there was an order from the court to say you apply indemnity costs at the rate of the agreement. Another major change, as I just alluded to, is the introduction of counsel fees to the scale under Order 63 Rule 82. Counsel fees have never been part of the Supreme Court scale, but and until recently in September 2011 they weren't even part of the, in respect of senior counsel, the county court scale, but they're now part of the Supreme Court scale, and time will tell as to whether counsel observe those or not, but it'll be the responsibility of the solicitor, the instructing solicitor, to recognise that if he doesn't, or if he does incur counsel fees over and above those provided for in the scale, he needs to be protected in reference to his client. If he hasn't advised the client, he won't be able to recover the difference on a solicitor-owned client taxation. The amendment does, interestingly, indicate the basis of charging daily fees. As some of you may be aware, daily fees were actually introduced in 1995. Invariably, they're not applied, and on occasions there still be orders for brief and refreshers, which I think are crazy. Unlike the county court scale, which provides that daily fees cover everything done on any day by counsel, including the first day, the Supreme Court scale provides that daily fees include all work done by counsel from the second day onwards. So it allows conferences and the like on the first day, and if there were special circumstances during the course of the proceeding where counsel needed to spend 4 or 5 hours with a special witness or whatever, you would need to be wary of that and apply for a special order for those conferences at the conclusion. Otherwise, you'll only get the daily fee as provided for in the scale. I think the responsibility in relation to instructing solicitors with counsel fees and keeping them in line with what will be recovered is important for the 15% rule, which I'll come to now. Previously, Order 63, Rule 85 existed only in relation to the cost of taxation when monies were paid out of a fund, and that would relate to an estate or a fund held by a liquidator, and was there to protect the beneficiaries of that fund, so that if a solicitor's bill was reduced by 1/6, that used to be referred to as the 1/6 rule, then they weren't entitled to any cost for bringing the bill to taxation, attending on taxation, and I believe it was implied they would have to pay the other party's costs as well. A similar rule applies under the Legal Profession Act 3.4.45, paragraph 2A, which applies a 15% rule in relation to taxation between solicitor and client. That is now covered in any event under Order 63, Rule 85, which stipulates that any bill of costs submitted for taxation, whether it be between parties, whether it be a payment out of a fund, or whether it be a solicitor-client taxation, if it is reduced by 15%, then the solicitor or the party presenting the bill will not be allowed the cost of presenting the bill or attending on taxation. Now that's the way it's worded. I was talking to one of the taxing officers yesterday who said, well, we'd still be allowed to allow them the fee for the summons on taxation, which I think be certainly representations made by me that is not the intent. This rule will have a lot of problems, in my view, in relation to interpretation. For example, we have, I don't know, we've got some personal injury practitioners here. A personal injury bill of costs is subject to a 20% reduction in any event. So that will need, and certainly if I'm preparing bills, I'll make reference to that, but that's something would need to be taken into account. There's the thought that you'd be less than prudent if you didn't include the actual fees incurred in relation to disbursements in a bill of costs, and therefore they may, by themselves, cause a 15% reduction. I don't agree with that. I think in relation to disbursements, you have a responsibility to ensure that you limit your disbursements to amounts that are recoverable, as you have a responsibility to limit your charges to what's recoverable. Fee agreements are constantly dangerous, and Peter alluded to the fact that in recent times they've been rendered null and void for various reasons. And my gut feel is that the new scale of costs, new Supreme Court scale of costs, is sufficiently rewarding that you don't need to enter into a separate fee agreement to get sufficient reward for the work you do. There is a discretion, obviously, to the taxing officers as to whether they do apply the 15% rule, and I think there'll be limited allowances for them to take issues other than, as I said, the 20% reduction under the Act in personal injury matters to exercise that. One of the issues that cause some people concern in relation to the amendments is the transition period, and it stipulates that it will be effective as from the 1st of April. And people are wondering whether that means that costs in relation to orders made prior to the 1st of April will be subject to the 15% rule. They won't, because they will be orders made for party-party costs, and they'll need to be taxed on a party-party basis, and as such they would be subject to the 15% rule, which relates to taxation of matters on a standard basis. I'm not sure what will happen in relation to orders presently obtained for interlocutory applications that haven't as yet been submitted for taxation. My general feel is that if a summons hasn't been taken out at this stage, that opportunity will be lost until after the proceedings concluded. But any matters that have been issued up to date will carry on. In fact, I had a matter yesterday which we did get was part heard and was adjourned till afterwards. So that's an indication the registrars are prepared to do that. Now, I'd now like to briefly refer to the amendment to the scale of costs, and this is a substantial amendment to what has previously been in place in the Supreme Court, and it follows the federal court format, which is limited to about 12 items. The new Supreme Court scale has been reduced from 47 items, I think, down to about 17 items, 19 items, 48 items down to 19 items, and the concentration is on hourly rates. The format of a bill of costs from this date onwards is also totally different. There will no longer be the instructions for brief element in a bill of costs, which confused a lot of practitioners, but what we basically had was what we called the body of the bill, and then the instructions for a brief element was the part of the bill of costs which related to evidence gathering. And the value of the work done under that particular item attracted a loading for skill, care and attention, which was dependent on complexity, length of trial, and etc. There will no longer be that item. A bill of costs will be drawn with every specific function performed, attracting a fee in accordance with the scale, and that at the end of the bill there'll be a loading across the board for skill, care and attention. Now, my gut feel is that loading will be somewhere in the range of 20 to 25% in relation to standard matters. Anything that is complex or out of the ordinary will attract a higher loading. For your benefit, I can address some of the scale allowances. The solicitor's rate now is $360 per hour, broken up into 6-minute units at $36 per unit. Of interest, support staff and unqualified personal assistants are entitled to be charged out at the rate of $270 per hour, or $27 per unit. Perusals are now allowed at the rate of $18 per folio when they were allowed at $6.40, so there's a 200% increase in relation to that. Drawing and engrossing is also substantially increased from about $35 to $65. And that rate also applies to letters. So in the past, there was a description of, or an allowance for an ordinary letter and an allowance for a special letter. Now, if you have a length, if it's necessary to go to great length to explain something, you'll get reward for it at the rate of $64.80 per 100 words. Electronic transmissions are no longer chargeable. However, there is an allowance in the scale for receiving and filing correspondence, in addition to, obviously, the perusing the content or whatever. Given that there is an allowance in the scale now for counsel fees, practitioners who appear on their own in lieu of counsel will be allowed rates similar to what is allowed or stipulated in the scale for counsel. Solicitors are now allowed fees for travelling and waiting in court, which is something that I think has been crying out for a long time. You're not in control of the court list and you get there, you waste half a day and you're prevented from doing something else. As I indicated, party costs, whilst they don't exist, at the end of the day, any existing orders on interlocutory applications or any existing orders on hearings that provide for party costs will be allowed on the party scales. Cost orders from here on in will probably merely make reference to costs on the Supreme Court scale, which by itself will take care of the scale to be applied. So it would naturally be up to 31st of March, it will be on the present scale, and thereafter it will be on the new scale. So there'll be a need to break up a bill of costs and part have instructions, part not have it, but that in time will work itself out. Just in summary, I think that the main points are necessary to get orders in relation to amendments and interlocutory applications. That's vital for the benefit of your client. I think that the abolition of party-party costs and the taxing of costs between parties on a standard basis should have the effect of reducing the disparity between chargeable costs and recoverable costs. And I think that's going to be rewarding for practitioners, because I think it may reinvigorate a client's desire to enter into litigation, which had waned in the past because of that disparity, and it was getting substantial. I was seeing examples where clients were being charged or recovering 50 to 60% of what they were being charged, which was outrageous. I think the introduction of a scale allowance for counsel fees will help to contribute to that reduced disparity. And finally, I just want to finish on saying that I think the scale is substantially increased and may provide sufficient reward to avoid getting involved in entering into fee agreements which you have a hassle with your client, and sometimes it dissuades your client from take action. If you're merely saying that we will charge in accordance with the appropriate Supreme Court scale, they'll be more comfortable with that than any suggested agreement. Yeah, happy to take any questions on any of that. Oh, sorry, what I should have said is that those scale fees are exclusive of GST. So when I'm saying $360 an hour, you apply the loading and then you add GST, so it's about $495 an hour, inclusive of GST.
Am I able to, in a VCAT matter, in my cost disclosure statement, costs agreement, simply say I will charge you in accordance with the Supreme Court scale applying from 1 April 2013. Am I able to do that?
You're able to do that, but you would need, in my view, you would need to explain that most orders in VCAT are in accordance with the County Court scale, and you're charging a higher scale, and explain
appropriately amended. In other words, with appropriate modifications, I will charge you. My scale of charges will be based upon what is in the Supreme Court scale.
Yep.
No reason?
No problem.
Why not? Okay.
Ray, Mark Bellamy from the TAC. Just a couple of points. First of all, that 20% reduction, of course, you mentioned only applies to work cover matters, not TAC matters. But in relation to the 15% rule, I have heard a novel argument that some cost consultants are going to be using in relation to matters where an offer of comp is served, that the 15% will not apply to bills reduced by that amount. But if an offer of comp is served, the taxation would have to reduce the offer of comp amount by 15%. Now, is there any scope for that argument as far as you know?
I think there's obviously that opportunity. I mean, Office of Comp or Calder Bank Office, in my view, should be explicit, and all that offer of compromise needs to say, or the Calder Bank letter, is that we are offering X dollars to compromise this bill, and in the event that you proceed to tax this will be taken into account for the purpose of 6385. Alternatively, if I received an offer of compromise, I would write back and make reference to the 6385 as to how it's to be effective. In relation to bills I prepare on work cover matters, I will stipulate in the bill that the 20% rule should not affect the calculation under 6385. So I think everybody has to be conscious of the fact that if you're making an offer to compromise that bill of costs, let's say if you make an offer to compromise that bill of costs at 10% reduction, you couldn't obviously rely on the 15%. So it just has to be explicit. I think common sense will prevail in time. There'll be some early rulings made. Unfortunately, for those of you that have appeared in the cost court, we're total inconsistency. So there'll be several rulings made, many of which won't agree with each other. And you'll be aware of that.
Any more questions?
Peter, this is for you. I've received a judgment on the 26th of March with costs. The judge has asked the parties to go and discuss the costs and come back on the 18th of April when, if they're not resolved between the parties, she'll make orders. Which cost regime am I under if we're unable to resolve those costs and we go back on the 18th? You need to answer.
I might give this some thought, some future thought. The costs regime starts on the 1st of April. That's when the new rules kick in. If the order for costs is made, I would be seeking some sort of clarification from the relevant judge. Or are you saying that the costs order has already been made and the judge is only wanting submissions on quantum?
No, the costs order hasn't been made. There's a dispute regarding whether or not there's a call to bank involved, etc. And she's told the parties to go away and discuss it. So it will be a fresh order on the 18th. My question, I suppose, is to protect myself or my client, should I go and get or issue a summons for taxation today?
Well, I don't believe you can issue a summons for taxation today if, in fact, the issue about costs is yet to be resolved. The issues I would be raising with the judge is, well, first of all, to clarify what the order is going to be, seek the order from at the highest level possible, and then raise the fact that the costs scale, or raise with the judge the extent to which the new cost scale is intended to apply. It may be that it's not intended to apply at all from the point of view of the judge. Do you have any comments you want to make?
All I'd say, Frank, is that when it comes to an order being made, you ask it to be made whichever way favours you. And if the order's made after April, you say, okay, well, we've got standard basis costs. The other side would be jumping up and saying, no, this should be orders should be made in respect to the judgment obtained prior to the introduction of the new rules.
My client will be more concerned about the recovery.
Well, it's probably academic then, if that's the case.
Okay.
Let's make this the last question if we can, please.
Have the costing registrars given any indication as to how they're going to apply what's a reasonable cost, particularly now that the scale costs might be much more than what the solicitor's charging in any event?
Sorry?
So if the scale costs are going up to $360 an hour or $400 an hour, and the solicitors are charging out at $300 or $250 an hour, do we automatically have reasonable costs?
No, there's a provision in the amendments which I didn't address, Order 63 Rule 42, which identifies what must be included in a bill of costs. Includes a requirement for you to stipulate in the bill of costs the hourly charge-out rate of the principal and the person handling the file. And the reason I think that has been introduced is to recognise the indemnity principle that you can't recover from the other side more than you've charged your client. So I think the registrars will address that aspect, and it's going to just make taxations cumbersome. Every item. If I was, let's say you're a practitioner who charges at $250 an hour, but under the scale you're entitled to charge at $360 an hour, and you're not rewarded in that regard, but then later on you're reduced to, you might take longer to draft a document than you're allowed on scale. So there's swings and roundabouts, and I'd be arguing that, look, this is, if the overall effect is that you're not seeking to recover more than you've charged your client, then it should be okay. They shouldn't just isolate items. So that's what I'd be arguing. I couldn't tell you what the registrars would do, but I think that's a logical way to approach it.
Thank you, Peter and Ray. On behalf of Greens List, thanks for attending. I'm sure everyone got something out of that, and hopefully our series will not run in April, being the end of the CPD year. So keep a lookout on our website for May, and going forward there'll be a continuing series in not only cost but all sorts of different practice areas. So thanks for your attendance.